Yes.
Adjournment request, if any, from item number 1 to 7.
I'd like to mention item number 4 in consent of the other side.
Item number 4.
Yes, Your Honor.
4 and 21.
You are for the respondent.
Yeah, I am for the rest.
As prayed for on behalf of the respondent, after having obtained consent from the counsel for the appellant, the matter is adjourned to give a date.
18 to and 21.
Before is a 21 be. And 21 also, we are adjourning.
Yes, simply. It is connected. All.
18 to 18 February.
18 to.
Yes, sir.
First.
Hello, Blake.
11 February.
Item number 6, my lord, item number 6,
What do you want?
adjournment, my lord.
You are for whom?
I am for appellant.
As prayed for on behalf of the appellant. Have you informed the other side? The
Yes,
term?
yes, my lord, I inform.
After having obtained consent from the other side. वैसे ही लिखना. Re-notify on so and so date.
26 February.
Highly obliged.
From item number 8 to 20, adjournment request.
With the consent of the other side, I beg to mention item number 16, Your Lordship.
16.
16. In this matter, Senior Counsel Mr. B. Datta is appearing. He sustained some injury in his hand, so he is unable to appear before this court today.
With the consent of the other side. Sometimes in March. All right.
Deeply obliged, Your Lord.
11 March.
Lordship, I beg to mention item 19, madam.
Yes.
No,
19 adjournment slip has already been circulated. All right. March. Yes.
16 March.
I beg to mention item number 11 and 12, Lordship, paying for adjournment
Or on behalf of?
on behalf of SAR made.
On behalf of the petitioner.
Petitioner.
All right. Number 11 and 12 all. PIL. Give the dates.
13 March.
May it pleases your lordship. Lordship, I beg to mention item number 17.
17.
Yes,
On behalf of respondent.
yes, lordship.
Have you informed the other side?
Yes, lordship.
You have informed or
Yes,
you
lordship.
just
We have informed, we have the consent of the other party.
on behalf of the respondent after taking of consent from the counsel for the appellant. All right.
I'm okay.
12 March.
Item 18, my lord, I am for the appellant. I have informed.
1-8.
1-8, my lords. But I was required to bring on record one affidavit. There is some delay, my lords. I seek 2 weeks time, my lords.
As prayed for on behalf of the appellant. Re-notify. All right.
16 February.
Inform the other side.
I have informed.
In the supplementary list, any adjournment request?
In supplementary item 23, madam,
Yes.
we are in the process of filing an affidavit, madam. Let it be called for, madam.
You have filed the affidavit.
It's under filing, madam,
You get it.
in the course of time.
Because this
Publish, madam.
cannot be adjourned, no?
Yes.
We need to see what
Yes, yes,
steps
yes.
have you
Yes.
taken? What prohibitory orders have you?
Fine.
May I please your lordship, my lord? Lordship, with the consent of the other side, I beg to mention lordship item number 25 to 27, lordship. Lordship,
25 to 27.
lordship, amicus curiae, lordship, Mr. H.K. Das, lordship, due to some medical emergency, lordship. He has gone to Delhi today morning, lordship.
As prayed for on behalf of the petition. As prayed for on behalf of the amicus. On account of his indisposition. Re-notify. All right.
25 to.
Deeply obliged, lordship.
Deeply obliged.
Any other request?
May I please your lordship? Lordship, day before yesterday I made a mention. I filed a writ petition on 15 December. I made a mention for listing the matter. Lordship was pleased to grant me the time of 24th February. This is a fresh matter. I want to on the matter. Can it be after Bihu? As a fresh matter?
All right.
Much obliged.
All right. Take the date now. Give the date.
My please, your lordship. In item number 2, busty service was taken and it was refused to accept,
January.
my lord. And to that effect, I have filed an affidavit yesterday. That
Respondent number 2, lordship.
Oh, choose here. Doesn't matter.
Daily list for orders item 1.
My lords, after that order, my lords, we have carried out certain other evictions also in September and in November, my lords. We like to incorporate those and file an updated affidavit, my lord.
No, where is your affidavit?
No, my lord, we will file, my lord. Some other, after that order, my lord, certain other developments have taken place.
No, that's all right, but then this.
We'll be
this-
filing, my lords, because it's going under, on November and September, my lord. I have the reports with me, my lords.
As prayed for on behalf of. As prayed for by the Learned Standing Council, Department of Forest. Let this matter come up for consideration on first week of March. By that time, the affidavit. But by that time, the detailed affidavit, as directed by this court on 29/8/2025, must be filed.
Always.
On 5/3. 5/3. Item number 2.
Yes.
My lord, against the order of eviction by the Tribunal of Senior Citizen, my lord.
Yes, who appears for the father? Respond number 2.
Lordship, I am appearing.
What do you have to say?
Lordship, in this case, Lordship, there is no prayer for maintenance, but Lordship, misbehavior prayer was there, Lordship. Due to
That's right.
misbehavior,
But then we are on a legal issue.
yes, Lordship.
The order may be justified, especially with respect to interpretation of the expression transfer
Lordship,
appearing in section 23 of the Act of 2007.
Lordship.
Have you gone through the order passed by this court on 17/12/2025?
Yes, Lordship. Yes, Lordship.
Correct?
Yes.
What happens to the daughter-in-law? This eviction, she also has a right to the household,
Lordship.
shared household. There are many other legislation which would be triggered.
But Lordship,
So what is your response to this? You need to respond.
Lordship,
Otherwise, it's state. Now you can ask for you can ask for maintenance. That is what the learned single judge, in our estimation, ought to have done instead of asking for lock, stock and barrel eviction.
Lordship, maintenance, I am not praying. The misbehavior they have done towards the
Misbehavior is not definite. Would you like to put in your response or should we decide on oral?
Lordship, in the writ petition, I have filed my one IA, Lordship, I have filed my affidavit in
No,
opposition
this
for stay
this is
vacating.
something which you'll have to say specifically. Because
Lordship,
we don't find any definite, accusation of misbehavior, except for the fact that there was some foul play with respect to sale of property, which the son denies.
Lordship. But
So
Lordship,
that could be collusive.
No.
Madam, that could be collusive. Now, in order to avoid any, in order to avoid effecting of that sale, this is a very convenient subterfuge.
Lord.
You don't sell lordship to everything that I say. You have,
but Lord,
you have to
but Lordship,
respond.
in this case, what happened in my
MS
petition,
Chatterjee, what role are you playing in this?
in the application,
Mr. Chakravarti, Mr. Chakravarti, who am I you?
Actually, I am for the
Okay.
Response number 5,
What-
Department of Social Justice.
what-
Madam.
So
We
you
don't
tell
have,
us.
Madam,
That time I had told you
My
to
lord, my
find
lord.
out. I mean,
the
really-
judgment your lordship was referring, actually, I could not lay my hands to that judgment. Your lordship was referring to some judgment passed by your lordship in.
not necessary. I mean, I'm not hunting for my judgments,
My lord.
but then
Reference, madam.
in an issue like this, if we interpret, see, we don't find any fault in the expensive interpretation of the word transfer.
Strict interpretation, my lord, lordship is correct.
No expensive we don't have any objection with respect to the expensive, not strict, expensive interpretation of the word transfer. Correct. We don't dispute that because that is what has been done by the Supreme Court in one of the matters. But here, the allegation of misbehavior was not that specific. Correct. And then the daughter-in-law also stays in the family.
My lord.
Where would she go? So therefore, a compromise has to be struck, no? The father has to
My lord,
decide. The father has to take a call.
Can this matter be referred to mediation, my lord?
All right, I think we are the best mediators.
My lord.
We are the best mediators. Now, can I ask the father to come here?
That would be
Father would be here
Yes, lordship.
and your client also can come.
My lord.
Will be here.
But there are some specific allegation against the son by
That's
the
right.
father
but
misbehavior.
I don't think you have any objection if we make some efforts at reconciliation between father and son.
No, lordship, I have no objection.
All right. So next date, what is the convenient date when both of them? How old is father?
85 years.
Oh, can he come to court?
Yes, lordship. He came for swearing the affidavit, lordship.
Take the
He has some problem like hearing problem, lordship, that we can communicate with lordship.
We have heard the London counsel for the parties. The respond number 2 / father is not happy with the appellant, bracket son, for the reason of the son and his family not taking good care of respond number 2. The learned single judge, by the impugned judgment, has directed the appellant to vacate the premises in which he had been residing with his family for a long time. After giving an expansive interpretation to the word transfer, appearing in section 23 of the Welfare of Parents and Senior Citizens Act 2007, bracket hereinafter referred to as Act of 2007. After hearing the contention of the parties, we are of the considered view that the stalemate between the father and son can be resolved if both are made to see reason. We say so also for the reason that with the insistence of respond number 2 for his son to vacate the premises, the daughter-in-law's right for a shared household gets adversely affected. From that apart, the learned counsel appearing for the appellant submits that he can also explore the possibility of an amicable settlement and payment of maintenance to respond number 2, who is already getting pension for a further decent living. Thus, we direct the presence of the appellant, respond number 2, and respond number 2 on 20th of February at 3 p.m. Let this case be placed in the chambers of the Chief Justice for further deliberate.
My lord, interim order passed.
Are we vacating it?
No, my lord, that may be accepted.
Are we vacating it today?
No, my lord.
Friday.
You're only escalating the tension. We don't say anything.
My lord.
That means it's continued.
Lordship, in
And maybe MS Chatterjee, Chakravarti, you will have to mediate.
But in fact,
We
I
are
am also
cautioning you,
mediator.
we
so
are
I
forewarning you that
I can
come
mediate.
prepared with this.
Yes,
Now,
I
it's a difficult thing, to placate father and son both when they're at loggerheads. But be ready with some out of the box, suggestions.
in the meantime, I can file my affidavit in opposition.
We have said interim order till next date. Interim order dated so and so. to be continued till the next day.
Lordship, in the meantime, I'll file my written objection.
You do that.
Lordship,
But now that when we would be addressing both the son and the father, I think that will not be required. We are very optimistic about it.
Lordship, already
You can
I have-
file.
Already I have filed one objection before the writ petition, writ court, Lordship.
It's afresh.
That's not annexed.
Ah,
So that
do it
can be
afresh.
also brought on.
With new thinking.
Lordship,
Don't take a rigid stand.
Lordship,
Don't take a rigid stand. After all, you have procreated him. He's your son.
Lordship.
You have your daughter-in-law.
What?
Let's see. Let us appeal to their reasons.
Obliged.
Item number 3.
You have filed objection?
Lordship, we have got no objection otherwise, but the petition is a conglomerate of 5 review petition of different order.
It's a conglomeration of what?
5 review petition and writ
No, no,
petition.
reasoning with respect to the delay.
Delay, Lordship, I have got no objection. Because in 4, 5 cases, it is 504 days. In one case, it is 514.
We are looking at this case only.
No, Lordship, here's
Here's class.
club.
What is clubbed
5.
together?
Yes,
Four
Lordship.
cases.
I don't think so. That's not the way you do
It's
it.
not as per High Court procedure.
No. File separate petitions. You withdraw this application, file separate applications in all the review, in all the matters.
No.
Don't have such deadpan expression on your face. We are asking
Mal-
you to do
Mal-
something. Say yes or say no, then we
Yes.
pass an order.
Yes,
So you withdraw this application.
yes, only liberty, my lord.
Take down. A composite application has been filed in about 5 cases for condonation on behalf of the applicant for condoning delay in preferring respective appeals. So stop. After some arguments, Mr. Anyway, for the respective appeal. What have I said? A composite application has been filed on behalf of the applicant slash appellant for condoning the delay. In the impugned judgment, there are several interlocutory orders. There are several intermediate orders which would be required to be appealed against. Stop. In that case, separate applications for condonation of delay would be required. After some arguments, the learned, what is your name?
S.K. Roy.
Mr. Roy, learned advocate for the applicant, seeks permission to withdraw this application in order to file appropriate applications for condonation of delay.
Yeah.
Once
When, my lord, I appeal will remain, my lord.
Appeal. Yes,
Then I have to
David.
file
Yes,
the,
file both, my lord. Appeal and condonation both. The appeal is also a club not.
Why to create so much of problems? We will condone the delay. You will raise objection there. We will hear everything on merits.
Yes.
Sure. Heard so and so for the reasons stated. Delay control.
No objection.
No effective objection on behalf of the respondent for condoning the delay. Detail you lick there. Appeal to be processed. Regular order of condemnation.
harmless.
For admission, item 5.
No clear theory. Yes, Mr. Panik.
May it please your lordship. My lord, to be honest, since the first date,
Now, when is Mr. Panik dishonest?
no, no,
You're always honest. To be honest, why?
as on the date,
Your submissions as on date.
As on the
of
date.
Now,
not now, the date on which the progressions took place, my lord.
what happened?
In this case, on an interpretation of whether
No, that we have followed.
Hmm.
Now, this order was passed for holding a meeting on 25th of
My lord.
October 2025.
24th, we had moved the matter. My lords were pleased to post the matter on 9th of January. Interregnum, 25th, it was held.
It was held.
It was held. Now,
What was the result?
result was that the respondent number 7, I mean, who was there, would come in and took the, I am not there. I'm out. It still remains to be seen that the interpretation which the Honorable Single Judge had given to the requirement of number 1, service of notice, and number 2,
No. The decision was not, the decision does not hinge on the service of notice.
I'm
Because
grateful.
it's not on service of notice. It's on clear 7 days.
Yes.
Clear 7 days means 1 day has to be deducted.
Yes.
For that, we have a lot many precedents.
No, I don't need a precedent. My if lordship permits, I would only read the relevant rule and
That's
the
all right,
subject.
but
Only one.
Then the entire matter has to be redone. No, after 25/10, the order has taken effect.
Lordship,
Now, what has happened there? You would be required to challenge the proceedings of that.
it has
not
been.
that.
We have challenged the qualification of the person concerned.
That's a separate cause of
No, no,
action.
that we have challenged on the thing that you could not have been, you're not eligible.
Anyway,
under
so
the-
we hear it after some time after review when the other side also will be here.
Yes, but
Have we issued notice?
why not?
Not here, not here.
They are not issued notice. It's coming for the first time.
Therefore, I prayed for the interim on day 1, but I must say I had over insisted on that early listing, and therefore it fell through without. I'm sorry for that.
You lost it on that day.
I took it. I take it that way. I take it that way.
All right, let notice be issued. 2 response numbers.
My lord. All.
They have not passed any order.
No. No, I take it on me, my lord. I made a mention, my lord, for that listing that day.
The issue raised in the present appeal is as to the requirement of 7 days clear notice for holding the first meeting, and whether this requirement is applicable for the second meeting as well. What would constitute a clear 7-day interregnum between the fixation of date and holding of meeting is also an issue which has been dealt with by the learned single judge. Mr. Banik, representing the appellants, submits that a determinative opinion is required to be rendered. Let notices be issued to response number so and so on step being taken by the appellant within a period of 2 weeks. Both modes returnable March.
Grateful, my lord. Blessed.
10th March.
10 point.
Item 7.
Yes.
Please, your lordship. It's a appeal preferred by the state of Assam lordship against the order dated lordship. It is in page 27 lordship. Page 21, it starts from page 21 lordship.
Lien granted to the post of associate professor is satisfied.
No.
इनको practice करना है। 1 मिनट हो जाता है। 2015, he was the director of the college development Council on a fixed basis, retaining an lien to the. It was only for 1 year. Yeah. Okay, thank you. And he was not even confirmed. The respondent was not permanently absolved.
Lordship, it's a tenure post, Lordship, 5 years tenure period is there, it's a outside cadre, Lordship. He was originally state of Assam, the assistant professor, Lordship. After that, he was granted 1 year lien period,
I am asking something post that you are coming back to the same thing.
Lordship.
He joined on the post of Director of College Development Council, that is CDC,
Lordship.
on a lien.
Lien,
On a lien for 1 year.
Lordship.
With the stipulation that after 1 year, he must come back
Lordship.
or resign
Lordship.
if he is absolved.
Lordship.
So you say that that was also a tenure post. He
Lordship.
could not have been absolved. So he overstayed the period of lien.
Lordship, as per the, after 1 year period, Lordship, we have terminated the lien, Lordship. Against that, Lordship, he has preferred a writ petition, Lordship, and in the writ petition, Honorable Court says that as because lien can be granted up to period of 3 years, Lordship, so he is, that termination is state, Lordship. And after that, he has, Lordship, completed more than 6 years period in the university, Lordship. And he has also approached before this.
Notice, let notice be issued to respond number 1.
Lordship.
Respond number 1 on steps being taken by the appellant state within a period of 2 weeks, both modes returnable matter.
Lordship, we have a business application.
No, we are not.
Yes, because Lordship, contempt case is filed by the Lordship petitioner.
In the meantime, वो आइए और वो दोनों साथ लिखते हैं ना. In the meantime, the impugned judgment shall remain in abeyance.
Oblige, Lordship.
18-3.
As an just a minute. Go,
Yes.
fine. Just. Taylor. The respondent, respondent number 1,
Lordship.
the sole respondent.
Sole respondent.
The sole respondent was while working as an associate professor in the Department of Geology at Jorhat Engineering College, took a lien for 1 year and joined the post of Director of the College Development Council at Guwahati University on a fixed term basis. The lien was granted only for a year with the stipulation that on the expiry of the lien period, the respondent shall rejoin at his substantive post, or else he would be required to resign if he is absorbed in the Guwahati University. The case of the appellant is that the respondent overstayed the period of lien despite the lien having been terminated. The learned single judge on the specious plea, on the plea that lien is normally for a period of 3 years, set aside the termination of lien by the and directed the state to directed the appellant to accept the joining of the respondent on the substantive post. Let notice be issued to the respondent on steps being taken by the appellant state within a period of 2 weeks, both modes returnable on so and so date. In the meantime, the impugned judgment shall remain in abeyance.
Oblige, Lordship.
On 18-3. Item number 8.
Number? And you are to.
May I please adjourn, this is an writ petition is filed by Union of India Lordship. Lordship will find the immune order by the learned.
Yeah. One second. Yes, tell us what has happened.
Lordship, in the previous transfer 2022, he has given Rongia as his choice place of posting, Lordship. And
Tell us what is this concept of tenure and peace? Is that the Sharma? Sharma, tell us what is tenure, what is peace? Suppose a person gives three options. Two are peace stations, but he is moving to tenure.
Lordship.
And he chooses something which is tenure for peace. Therefore, would it be accepted as peace or tenure?
Lordship, if 1 year that
Are you aware of it? Are you clear on the point, or we should postpone it for a later date?
Lordship.
What lordship?
Lordship may postpone it.
Rangia is a tenure posting.
Rongia,
Posting?
he's give transfer policy paragraph 17 said when someone gives a choice posting, it will be treated as a tenure posting.
Therefore, I said that you are absolutely mistaken. Suppose he's moving from peace, from tenure to peace, right? He's moving from tenure to peace. He has to be given a peace station.
Lordship.
And he says that, no, give me Gantok. He wants Gantok. Gantok is basically a tenure posting, not a peace posting. But he voluntarily accepts Gantok, therefore it will be treated as peace. Is that the case?
Yes, Lordship. Here he treated Rangya as,
Don't forget about Rongya. We are asking you for an example. Please get ready, make a chart, then tell us. We are not saying anything. As prayed for on behalf of the petitioner, Union of India.
the
and others.
contempt is pending, Lordship. In the cat, if they have filed a contempt in the,
So you're not ready. You're not ready. What do we do?
but Lordship, paragraph 17 of our policy says that Lordship, when
Let us see the policy.
Lordship, page 33.
You tell the tribunal that the matter is pending before the High Court. Come after you. You'll have to go through it. You also get ready. Mister. You are creating confusion for yourself. When you are asked to select for peace stations, you ask for tenure station. And therein lies the problem.
Yes, yes.
Clause is clear, Lordship.
You can't have your cake stored it in refrigerator. You would preserve that cake and you would eat it too.
Yes.
You can't have both. We will be forced to stay.
He stayed there for 2 years. Now, after completion of 3 years,
Now, my lord, already 3.5 years.
3.5 years, but the tribunal had directed to consider his case in.
When is the contempt posted before the tribunal?
That I don't agree.
You don't press that contempt now, we will decide.
Lord.
Okay, let this matter come up for consideration. On immediately after. Be ready on that concept. Where is that policy decision which says that if a person chooses,
That
it gives
is
an
here.
option.
Page 33, clause 17.
Let this matter come up for consideration on when are we reopening? 19. On 20th of January, the learned counsel for the respondent, however, submits that he shall not press the contempt petition before the tribunal till the next stage.
Lost.
Item 9 and 10.
Item 9 and 10, my lord, we have not received any communication from the registry lordship. Lordship may kindly take up this matter after 2 weeks, lord.
After?
2 weeks, lord.
Next side.
My lord, appeal may be hard on merit, actually. They will take much time in furnishing instructions.
In item number,
Where is that order? We have passed some order.
in item number 10, lordship. WL 336 of 2020.
141 or 349?
No, you have given item number 8. Give us item number 10.
Your lordship has passed some order to take instruction, lordship.
You have given 8.
Where is Mr. Das?
Lordship, due to some medical emergency, lordship, he is in
Let
Delhi,
this
lordship.
matter. Why did you not mention it in the beginning?
We have not received any instruction, lord.
We are not ready to accept that you have not received any instruction. On the ground of illness of the council, we will.
Lord. No.
You should have said that in the beginning, no? You should have taken consent from them.
Commissioner, my lord, notice may be issued and matter may be hard on merit. It is palpably wrong judgment, my lord. I can prove it.
All right, let the other side also be ready to contest you. Okay, a prayer for adjournment has been made on behalf of the respondent on account of non-availability of Mr. H.K. Das, learned standing counsel, Guwahati High Court, who appears in this matter. Re-notify on 22nd of January.
Lord.
I point out one thing, my lord. Item number 10, my lord, the learned single judge is interfered with the appointment of the Respondent number 7. However, he is still continuing the post in the.
On that day, you say all that.
Item 13.
Which item?
Item 13.
May it please, your lordship.
We have heard this matter, no?
No, lordship, it came for the first time.
No, but we have been, which is that matter? Log, lot record examination, six.
was there.
Where is that matter?
We have fixed when.
The matter had traveled to Supreme Court. From there, it was remanded. Not in your matter, but the issue is same. Is it the same thing where for the examination, the minimum qualification is earlier was higher secondary, now it is
lordship, no.
graduation?
No,
What
not
is
the,
this for?
not the same thing, your lordship. Just going directly to the point, your lordship.
Okay. Now we will hear that. Let this matter be listed along with so and so on 6th of.
I'll tell you. Mr.
Mr.
Anand Bhuya was
Please
there.
point out the number.
Ora will, Anand Bhuya was there day before yesterday. Borgohai appear किया था. Borgohai.
Along with so and so on 6th of February and on that date. Uska date कब रखा है?
Okay.
All right, we can't tell you the date now
Lordship.
because it will be listed on the same day.
Just a second. Item 14.
Yes.
The lordships. My lord, the petitioners before your lordships were working as casual labor under the BSNL. So subsequently, my lord, some of the casual employees who were junior to them, they have been retained by the BSNL authorities and they were placed under the contractor, my lord, in the year 2007, my lord. And the 24 numbers of junior persons were retained by the BSNL, my lord. And thereafter,
Your services have been handed over to a private contractor.
private contractor.
But with the stipulation that you shall be retained in service.
Yes, my lord.
What difference does it make? You are also getting the same.
No, my lord, not same pay, my lord. The pay given by the contractor was much less than given by the BSNL. And thereafter, my lord.
Who appears for BSNL?
Thereafter, my lord, although
Who appears for BSNL? We have followed.
Yes, my lord.
No.
Standing council. We have served a copy.
No standing council is there.
My lord, my name has been shown as a standing council BSNL, my lord. In the cause list, my lord.
Let notice be issued to respondent / BSNL on steps being taken by the petitioner within a period of 2 weeks. Both modes returnable on March.
16 March.
Obliged, my lord.
Item 15.
May please, your lordship. Lordship, in this matter, we need further 2 weeks' time to file our reply, lordship.
You had taken time on the last occasion also. Is the same thing about the minimum
Lordship.
35% or 25%. What you have been settled with 35%.
Lordship, kindly grant us to.
मैं कुछ और पूछ रहा हूँ. I will grant you time, but is this the same issue where minimum required 50% is being insisted for?
No.
What's your high grade? Mr.
Madam.
Mr. M.K. Chaudhary had been appearing in this. He's on hunger strike.
Lordship, I was instructed.
So we will grant adjournment, no difficulty. Do we say that he's on hunger strike, therefore he wants an adjournment? I can say that. Without any offense meant.
I was supposed to take time, Lordship. That's why he is not here, Lordship. Otherwise, he would have.
Are you right? Are you making a correct statement?
Lordship, I was supposed to take time in the morning, Lordship. However, I could not.
No, in
contact
the
one
morning
of
also
the
we would have
restaurant-
asked you. What is the cause? What is the reason for unavailability of Mr. Chaudhary? Doesn't matter. As prayed for on behalf of the petitioner,
Lordship.
let this matter come up for consideration when you want it.
Any date on in the month of February, Lord?
February, March. In the month of March. Or it's the same matter where because of some judgment in a suit long time back.
Lordship.
All. 13th of March.
13 March.
Much obliged, Lordship.
13th of March.
Supplementary list, item 22.
It's the same subject.
My lord,
Yes.
the petitioner before your lordship is a 77 years old woman, my lord. Neither she is a borrower, neither a guarantor, but her property.
After the possession has been taken, everything has been done. Now, is it not a misadventure on the part of
Well, no notice, not a single notice has
that-
been issued to me. And lordship will see one thing, my lord. Bank had issued a NOC in her favor, page 33.
Yes, Sharma. लेकिन इसको entertain कर नहीं सकते, नहीं सकते। You are appearing for whom, madam?
I am for 1 and 2, Lordship.
1 and 2
Yes.
and 3 and 4. Notice, let notice be issued to the respondent. Notice to 1 and 2 is accepted by IMS RB Bora. Learn your signing counsel,
Junior government advocate.
the junior government advocate. Notice to respondents number 3 and 4 shall be issued on steps being taken by the petitioner within a period of 2 weeks, both modes returnable on sometimes in early March.
My lord, the only simple prayer, my lord, no course is acted, my lord, in view of the notice.
Sorry.
10 March. Item 23.
Well, I beg to appear through VC, Millard.
Yes, Mr. The affidavit filed by Mr. Gogoi is not here. Mr. Gogoi also is not here.
Millard, I have seen the affidavit, Millard, and there are similar orders which were passed in the earlier years as well. And in fact, Millard, the first, if your lordships don't have it, Millard, then maybe it can be passed over. Because they acknowledge the use of commercial nets.
Goswami has come. No.
Yes, Mr. Goswami. You step into the shoes of Mr. Gogoi.
But we have filed an affidavit today.
Huh?
We have filed an affidavit to indicate that.
Where is that affidavit? Give us a copy.
Yes, Lord. You know, we have filed it today morning, Lord. Sorry. Whatever. Basically, my lord, we have instructed the deputy commissioners to issue prohibitory orders. But it's a custom, my lord, everybody.
Mr. Fukin says that this is what you have been doing for all these years, but you're not effectively, implementing it. You're not stopping the fishing in Kaziranga waters.
We have stopped everything. But this bihu, well, it's a custom in Assam, my lord, to fish, my lord. It's very difficult to absolutely ban it, my lord. We are trying, my lord.
Customary rights, what will prevail? Consuetudinal licenses cannot be given, no?
Yes,
if there is a specific law.
true, my lord. True, my lord. We try our best to, my lord, stop them, my lord. We have issued all 3 deputy
But
commissioners.
for this 14th of January, what are your steps?
My lord, the deputy commissioners are issuing prohibitory orders for 14th March.
That on paper, you can issue anything.
13th actually is more relevant, Milan, because 13th is Uruka. That's the eve of Magh Bihu, Milan. And that night, Milan, 13th night.
Mr. Goswami submits that no fishing shall be done pursuant to the prohibitory orders on 13th. And then we'll take up the matter on the next date.
My lord, may also my limited
Subject
prayer,
to
Milan.
the affidavit filed by Mr. Cooken.
Milord, and one more limited prayer, Milord, that some of the respondents may be held, Milord, accountable to ensure that, Milord, this happens. Respondent number 3 to respondent number 11, who have, otherwise I wouldn't have implemented them, Milord, because they should be, if your lordship mentions that, that'll go a long way, Milord, in implementing.
The Mr. Goswami, learned additional advocate general, that series of prohibitory orders have been passed preventing any kind of fishing on 13th of January in water body located in Kaziranga Reserve Forest. Kaziranga Reserve Forest.
National Park, Milord.
Kaziranga National Park and Tiger Reserve, Milord.
Kaziranga National Park, Tiger Reserve. Mr. Goswami submits that the concerned DC shall be under the obligation to ensure that the prohibitory orders are
Implemented.
implemented.
Milord, as well as the superintendent of police, if your lordship's
He may
please.
take the help of the superintendent of the concerned superintendent of police to stop any untoward activity in the especially on 13th for Granville. Unless this matter on 27th of April.
Deeply obliged.
Obliged, deeply obliged, Milord.
In Assam, my lord, there is a peculiar practice of, my lord, committing theft socially, my lord, on that day, my lord.
Milord, actually 13th night, Milord, there is the significance is really of a gastronomic delight, Milord, because the fish and duck, Milord, are the
You may be
major.
absolutely right, but there is some substance in the argument of Mr. Goswami, no?
Milord, that's what ultimately what weighs, Milord, whether it's the statutory prohibition, Milord,
That we
or the
said
tradition.
in the first instance, we told him, we confronted him that you
My
don't
lord.
expect us to follow consuetudinal, practices.
Milord, and in fact,
That is
Milord, I will
particularly
place
against
that.
the law. Anyway, we'll
Exactly,
see.
Milord.
On 13th, Mr.
And in
Cooken,
fact, Milord, earlier there was a provision, Milord, section 33, which permitted the chief wildlife warden to regulate fishing. And that particular provision, which was section 33, subsection E, that was
there should
deleted,
not be
Milord.
any fishing in hordes and all that.
Right now, I'll talk to them, my lord. All the decisions.
All right, yes.
Deeply obliged.
Item 24, 27-2.
May I please, your lordship?
This is pre-deposit, yes.
May I please, your lordship? Lordship, I beg to mention for adjournment for today, lordship.
Why did you not mention it in the morning?
Morning, lordship, it is mentioned, lordship. I have not considered the other side, lordship. And also, so I have not mentioned it, lordship.
This is we are of tentatively of the view that in these matters there should not be any insistence for minimum payment. Correct. So I think he's to gain, provided he argues.
This matter pertains to DRT and SURFACE.
We know that. That's what we are saying. We are particularly of the view that for a matter like this, for any order of the tribunal, I mean, this here he wants the sale deeds to be sent for forensic examination.
And that matter, lordship, in original application, my lord, if I'm
Are you aware of the new Supreme Court decision, judgment by Justice Pardiwala? This section 28 embargo is not there for an order like this. But he is not arguing, what do we do? As prayed for on behalf of the petitioner. and agreed to by the council for the respondent. List this matter for consideration on 26th of February.
26 February.
Daily list for hearing item 20.
Lordship, in this case, your Lordship, I am seeking some accommodation, your Lordship. In fact, your Lordship, there is a new scheme called UPS has come. I have asked my clients whether they will be covered by that UPS scheme, your Lordship, and they have told me today morning, your Lordship, that some of them will be covered of members of the association.
Mr. Pothak, learned advocate for the petitioner submits that some decision favoring them, favoring the case of the petitioner.
Some of the petitioners, not all.
Some of the petitioners is on the anvil. He would like to wait
Lords,
for some time before addressing this.
Lords.
Let this matter come up for consideration March end under the same heading.
Lords.
24th March.
24th, leave load.
Three times for them to vote. Well, Mr. Pothak can use the time